Good morning, ladies and gentlemen, and welcome to the second day of the European Data Summit Ready for Competition. We have great full program for today, and I would like to make a small overview over the program before us. We're going to start with Winfried Veil and the blind spot of the GDPR, following the discussion with the Digital Minister of Taiwan, Audrey Tang, as we already discussed yesterday, we are continuing with the with the Data Governance Act at 10:45 with a focus on data markets and data intermediaries. And in the afternoon, we're starting the discussion regarding open data and the use of data in the public administration with the French Minister of Public Administration, Amélie de Montchalin, and CEO of the German government, Dr. Markus Richter. In the afternoon, we have the Privacy Director of Apple, Mr. Gary Davis, following a really passionate discussion when it comes to the biggest data breach in history, real-time bidding, again with Johnny Ryan. In the late afternoon, we're talking about the digital strategy of the European Union, from strategy to execution, and we are closing the day with the data usage during the pandemic. But now it's my greatest pleasure to introduce Winfried Veil. We have many data specialists in Germany, but I believe nobody can explain the complexity of the data world as Winfried does in a landscape way. So dear Winfried, what are the blind spots of the GDPR? The floor is yours.
Thank you, Pencho, and thank you for inviting me to this great conference. And yeah, dear ladies and gentlemen, it's early morning, and my task is to wake you up a little bit, and I hope that I will succeed to do so. The content of my remarks come close to heresy, so maybe I will succeed in being able to wake you up a little bit, which is criticizing the GDPR. I have to make a disclaimer. I'm working for the Ministry of the Interior, but here I'm only on my private expenses. I took a day off even today, so it's just vacation for me. I took part in the GDPR negotiations from 2013 to 2015, but since then I'm dealing with data protection only on a scientific and a private manner. So let's start without delay. If you're reading Commission papers, you could think, is it there now? It's there now. Okay, great. If you're reading Commission papers, you could think everything would be fine with the GDPR. You are reading about, no, it's not. Okay, sorry. You are reading about the GDPR as a gold, I can't see the, sorry? You have to use the clicker. Sorry. Yeah, thank you. There it is. If you're reading Commission papers, you could think everything would be fine with the GDPR. You are reading about the GDPR as gold standard. You are reading that it is a fabric of a success story. You are reading that the GDPR created a global upward convergence. You are reading about a thriving data-driven economy created by the GDPR. And you are reading about a common European data space. In sharp contrast to that, my opinion is that the GDPR has to be reformed and repaired urgently. The GDPR creates tremendous problems. Here is the case for fundamental criticism. We observe huge legal uncertainty. Still, 3.5 years after the GDPR came into force, there are about 30 preliminary ruling procedures at the European Court of Justice right now, with an uncounted number of questions. We have enormous bureaucracy. We observe an impressive unwillingness to obey the legal regime, what we call in German the Vollzugsdefizit, the enforcement deficit. We heard yesterday an impressive lesson by Ryan and about the Vollzugsdeficit. During Corona pandemic, we had the clash between data protection and health protection, which with lots of unsolved questions. My impression is that voiced GDPR criticism is only the tip of the iceberg. There is even more displeasure about the GDPR that remains unvoiced. One reason for the silent displeasure is that the structural deficits of the GDPR are not recognized and therefore not named. Let me reveal 13 of these structural deficits, and don't be anxious, it will be only a 15 minutes lecture. The GDPR follows the one-size-fits-all approach. The same obligations apply to every controller. GAFA, Google, Amazon, Facebook, Apple, have to fulfill the same obligations as the bakery around the corner. The tax authority has the same obligations as the internet blogger, as the hobby photographer, and as the sports club. The pharmaceutical industry has the same obligations as non-profit organizations. And not only the same obligations apply, but the same obligations apply to every processing, regardless of whether money is earned with the processing or not, whether the processing is self-interested or serves the common good, whether private or public purposes are pursued, whether it is an everyday process or a complicated algorithm. This one-size-fits-all approach is far too undifferentiated, and it is unfair. It does not take into account the capabilities of controllers. It does not take into account whether the processing itself is protected by fundamental rights. And it is unnecessary. It basically treats low-risk and high-risk data processing the same way. Often the one-size-fits-all approach has the effect of a sledgehammer to crack a nut. The GDPR follows an all-or-nothing approach. That is my second basic criticism. If there is personal data, all rules of data protection law apply. If there is no personal data, there is no regulation. That is very undifferentiated too. The GDPR more or less knows only two categories of personal data and sensible personal data. That I wear glasses is a sensitive date. My credit card number is not under GDPR. Pretty undifferentiated as well. By extending the concept of personal reference, for example, to IP addresses, personal data becomes boundless. There is almost no longer any non-personal data in the GDPR world. On the other hand, the GDPR does not cover if anonymous data are used to enable the re-identification of data subjects or to discriminate against certain groups of people. Third point, in the GDPR, the principle of prohibition applies. Processing personal data is generally prohibited unless there is a legal ground for permission. This regulatory technique requires numerous exceptions. These are regularly the subject of disputes and legal uncertainty. This regulation technique is, as a matter of fact, hostile to processing. Its basic idea is behavior control. Processing of personal data is somehow regarded as socially undesirable. The consequence is that even processing that is protected by fundamental rights and socially desirable is under constant pressure to justify itself. The general suspicion against every controller has a symbolic effect that triggers so-called chilling effects. That means citizens no longer make use of their fundamental rights, although they would be entitled to do so. Here is an extreme example. That's a kindergarten in the German city of Dormagen, and this picture was part of the documentation. The blonde girl in the middle was given when she was leaving the kindergarten. In this case, technically, the kindergarten was probably even right to do so under GDPR. It was a public kindergarten. They did not have a legal ground for processing pictures. And obviously, they spared the effort of obtaining and documenting consent from 38 parents, if I have counted rightly. The principle of prohibition inevitably leads to such aberrations, even if they were not intended by the GDPR. The principle of prohibition also leads to the privatization of the social, as you can see, and it leads to the juridification of the everyday. Fifth point. The data protection law is input focused. It primarily regulates the collection of data and the storage of data. Therefore, different protection needs of individuals are hardly taken into account. The input orientation of data protection law prevents the urgently needed political debate on the question of which exact uses of data should be permissible or maybe forbidden. We rarely discuss whether a specific data processing operation should be permitted or prohibited. The input focus also prevents the recognition of the output as valuable. Focusing on data collection input blinds us to the benefits of data processing output. The GDPR knows purposes of processing. It knows interests, legitimate interests by private actors, public interests by authorities. It knows risks, and it knows harms. But the GDPR does not know benefits of data processing. Benefit is not a legal category of data protection law. The term does not appear in the legal text. The GDPR is blind to the benefits of processing personal data. The fact that data processing can also have benefits is only recognized in a few recitals in the GDPR. The focus is on the individual processing interest of the controller on the one side and the individual prevention interest of the data subject on the other side. Of course, the public interest appears in the provisions, but in a very incoherent way. And there is another problem. The public interest cannot be pursued just like that. If public bodies want to serve the public interest, there needs to be a specific law, usually a sector-specific law, that specifies under which conditions the public interest may be pursued. And if private individuals want to process data in the public interest, it becomes even more difficult. Reporting a criminal offense is just provided for in the GDPR, but not data altruism, data donation, and other things. It is only foreseen that a private individual acts in his own interest or in the interest of a third party, but not in the public interest. 8. The GDPR is based on old-fashioned concepts that are no longer problem adequate. The GDPR is linked to the processing of individual data. They are treated like stones. They are treated as if they were objects. They are treated as if they were a commodity that could be kept in short supply, and this invites many misunderstandings. All personal data appear to be equally worthy of protection, and many think their data would belong to them. This all fails to recognize the nature of data as information, which is data are incorporeal, data are non-consumable, data can be reproduced at will, and data are non-rival. That means that they can be used by numerous persons at the same time. The information content and the economic value are context dependent. The individual date is irrelevant in many data processing operations, such as big data, algorithms, and artificial intelligence. Thus, it is not adequate that the GDPR concentrates on the single date. 9. The GDPR is linked to processing by a single controller, and it's linked to processing in a central local processing facility. This is not adequate for today's data processing as well. Think of cloud computing, the Internet of Things, platforms, blockchain, and other complex actor networks. The legal institutions of the GDPR that regulate responsibilities when multiple actors are involved, processors and joint controllers, are insufficient. This has become obsolete due to global networking. In many cases, data processing can no longer be attributed to a fixed physical resource. The principle of purpose limitation excludes accidental discoveries in the field of science, for example, the discoveries of correlations. And the principle of data minimization excludes a priori processing based on the retention of data that is in the public interest. 10. The GDPR does not even know what it wants to protect. It is based on the fundamental right to data protection, and according to pure doctrine, any processing of personal data is an interference with this fundamental right. However, data protection alone does not indicate when such interference is justified. This can only be determined if another protected interest is added. The Data Protection Directive from 1995 still saw this protected interest in particular in the privacy of natural persons, so in the privacy right. The GDPR no longer even mentions privacy or private life. It remains unclear whether the GDPR protects privacy, the right to personality, the right to informational self-determination, or other rights. Instead, the GDPR postulates that it protects the fundamental rights and freedoms of natural persons. The term rights and freedoms is mentioned 77 times in the GDPR. However, if the GDPR is supposed to protect all rights and freedoms, this leads to an overload for controllers, as they have to take all these rights into account. Moreover, uncertainty leads to disappointment for data subjects when their expectation that the GDPR will protect all their rights cannot be met. 11th point, the GDPR contains 82 balancing tests. That means there are 82 provisions in the GDPR according to which every controller has to do a balancing of rights and interests. There are 3 fairness tests, 8 balancing of interest tests, 2 compatibility tests, 11 suitability tests, 30 necessity tests, 12 appropriateness tests, 3 proportionality tests, and 13 risk assessments in the GDPR. The GDPR contains these obligations for every data processing citizen, not just for powerful companies and authorities. In the absence of a precise definition of the protected good, of the Schutzgut of the GDPR, there is also a lack of clear standards for these various balancing tests. 12. The basic assumption of the GDPR is that there is no longer such thing as trivial data. The law therefore never sees the processing of personal data as risk-free. It imposes obligations that must be fulfilled preventively, that is, before any processing can begin. Controllers must determine the purpose of their processing. They have to define their interest. They have to seek a legal basis for their actions. They have to balance, as we have seen, rights and interests. They have to comply with transparency requirements. They have to cite legal basis. They have to provide information on legal remedies. They have to comply with the requirements of written form. They have to comply with the obligation to state reasons. They have to meet the requirements of certainty, and they have to document everything. The GDPR has a largely preventive character. If you are a controller and if you want to process personal data, there is not just one current legal obligation, but a cascade of 68 legal obligations in total. Of course, depending on how you count, I counted 68. This is a hypertrophy of obligations. Keep in mind, the less is more paradox. Too many obligations lead to the erosion of the will to compliance. And in addition, many of these information, documentation, and verification obligations cause bureaucratic costs for citizens, business, and administrations that is hardly offset by any measurable benefit. In summary, it can be said that the obligations of the GDPR probably represent an encroachment on private autonomy. It is true, last point, that the economic or social power of a private party can lead to threats to fundamental rights. This is particularly debatable because of the information power of certain internet companies, but also of insurance companies, credit agencies, and so on. However, in the GDPR, the existence of informational asymmetry is irrelevant. Market dominance, discrimination in mass transactions, or the provision of public communication spaces do not create stricter rules for the controller. The GDPR does not contain any regulations that are specifically linked to an imbalance of power between controller and data subject. On the contrary, the GDPR even strengthens the large companies. Established and large companies obtain consent more quickly and easily than newcomers and SMEs. And they have the money and the manpower to fulfill the rather prescriptive obligations of the GDPR. What can be done in the face of this unfortunate legal situation? Well, the law is what it is. A major data protection overhaul or reform or even a revolution is unlikely. It is politically unenforceable. Unfortunately, it also fails because of the European Commission's monopoly on legislative initiatives. This is, of course, a democracy problem. No national parliament, the European Parliament, no citizen has the chance to change the law. We are dependent on the European Commission's will or unwillingness to do a reform. But perhaps a creeping process of rethinking is just beginning right now. At least we currently see a move away from the one-size-fits-all solution. Rules that treat all data-related matters the same are definitely not sensible. Sector-specific regulations would be better. The EU data spaces point into this direction. In the legal policy debate, I also observe a shift towards the benefits of data processing. Data trusts, we heard about yesterday. Data donation, data altruism are the key words. These are still tender shoots, but the opening clauses of the GDPR allow for the enactment of sector-specific regulations in certain areas. The EU Commission will not like to hear that, but there are around about 70 opening clauses in the GDPR. Data use regulations could be enacted. Data use in the public interest could be privileged by law. Benefit could be introduced as a category of data protection law. The GDPR could also be interpreted in a different way. Perhaps it will be possible to see data protection law not only as a right to prevent, but to transform into a right to enable. At least is to be hoped. Thank you.